Thanks for that introduction, and thanks to everyone for listening in today. I apologize for the delay and the late start. We had some technical issues with the webinar platform, so I do apologize. Thanks for tuning in today. We're going to be stepping through a number of issues relating to compensating employed physicians. In myself and my national practice, I work with a number of the largest healthcare organizations in the country on their employment of physicians and the establishment of physician compensation models. I'm hoping in today's session we're able to step through some of the issues that are relevant to your organization and that you're able to have some takeaways that you can immediately implement going back and working with your compensation team. So thank you for participating, and we're hoping to step through, again, some key concepts and national trends for your consideration. Again, my name is Joe Wolf. I'm an attorney with Hall Render. We're the largest healthcare-focused law firm in the country. My practice focuses on physician compensation, stark, and healthcare evaluation issues, and that's why today's content really dovetails with with my practice and my area of focus. Moving on to slide 3, this program is intended to be a general discussion of legal and business valuation issues. It should not be taken or relied upon as legal valuation or business advice. The presentation may discuss hypothetical scenarios, but those are intended just to elicit thoughtful and lively discussion, and they won't represent actual events. Here's the agenda for today's webinar. We'll start off with some introductory concepts using real-world examples. I'll take a deeper dive into the regulatory standards. We'll talk about drafting actual employment agreements. We'll discuss case studies and wrap up with a Q&A. So let's start off with some introductory concepts, moving here onto slide 6. When we look at the industry and think about employed physicians, the reality is that we're seeing more and more employment arrangements with referring physicians, with hospitals, health systems, and affiliated medical groups all looking to an employed physician strategy. The bottom line is, as you enter into any of these arrangements, that you focus on defensibility under the Stark Law, defensibility under the anti-kickback statute, and also the tax exemption rules. All three of those categories of laws are relevant and important. When we think about the arrangements and how to ensure that we have defensible compensation arrangements, it's very important to focus on what I call the 3 tenets of defensibility, and those tenets are fair market value, commercial reasonableness, and not taking into account referrals. That's critically important because all of the case laws involving employed physician arrangements have focused on those 3 areas. We've also seen an uptick in enforcement. There have been a number of recent cases and settlements involving employed providers, and in many of those cases we've seen very large damage figures. And because of that, I think that physician compensation continues to be an area of what is often referred to as enterprise risk. Because the penalties are so substantial, there's always a risk that you could, there's such a substantial risk that if you have a glitch issue with your employment arrangements or their compensation models, that could result in significant and substantial damages, and that's why it's an area of risk that needs to be mitigated. It's important as we just jump into employed physician compensation models that we think about some of the emerging best practices in the industry. Many organizations are focusing on streamlining and developing effective corporate structures. They're aligning their employment models under common entities, maybe a system-affiliated medical group that holds all of the physician and provider employment arrangements. We're seeing the development of governance structures that oversee employed physician arrangements. We're seeing consistent internal contracting and compensation processes being developed. We're seeing the periodic monitoring of existing compensation parameters and thresholds, perhaps a process that tests compensation models against certain thresholds, and if compensation exceeds those thresholds, they are kicked out for additional fair market value analysis or approvals. And also internal or external documentation supporting fair market value and commercial reasonableness as part of the process is also something that we're seeing on multiple with multiple healthcare organizations across the country. So those are the big background concepts and trends that we're seeing across the industry. When we look at the environment itself and the industry. Like I said, there's been enforcement both at the federal and state level in recent years. We're seeing most of the enforcement actions being driven by whistleblowers that are internal to the healthcare organization. So these are people that have the background facts, some of the supporting materials, perhaps the copies of the contracts involved and so on, and then they bring a whistleblower action. And because of the way that the Starkening and the kickback fit together, there is risk of substantial penalties, civil penalties, criminal liability. Also, if you run into